If you're caring for an adult with disabilities, there's a question that can feel overwhelming to even think about. Who will take care of them when I no longer can? It's not just a legal question, it's a deeply personal one about safety, dignity, and your child's future. I'm Anna Burr with Burr Law. Today we're talking about guardianship for adult children with disabilities, when it makes sense, when it might not, and what other options you should consider as a part of your planning. Because the goal isn't just to put a plan in place, it's to create the right plan, one that supports your child while respecting who they are. Let's start with an important shift when your child turns 18. Legally, they're considered an adult. That means even if they still rely on you for daily care, you no longer automatically have the authority to make medical decisions, access certain records, or maintain finances on their behalf. For many families, this can come as a surprise, and it's often the moment when parents begin to realize that additional legal planning is needed. Guardianship is one of the most well-known options. A guardian is someone appointed, typically by a court, to make decisions for another person who is unable to manage certain aspects of their life independently. Depending on the situation, guardianship and conservatorship can cover healthcare decisions, financial matters, living arrangements with daily care. For individuals with significant or developmental challenges, guardianship and conservatorship can provide a strong and necessary layer of protection. It ensures that someone has clear legal authority to step in, advocate, and make decisions when needed. But guardianship is also a significant step, because in many cases it involves removing or limiting your child's legal right to make certain decisions for themselves. That's why it's important to pause and ask, what levels of support does my child truly need? Are there areas where they can safely make their own decisions? How can we protect them without taking away more independence than necessary? For some families, guardianship is absolutely the right choice. For others, it may be more than what is needed. If guardianship is appropriate, one of the most important steps you can take is nominating a guardian in your estate plan or will. This allows you to identify someone you trust deeply, share your perspective on who is best suited to care for your child, and provide guidance for the future. While the court will ultimately make the legal appointment, your nomination carries significant weight. It gives the court a clear starting point and gives your family clarity during a difficult time. Now let's talk about alternatives, because guardianship is not the only option. Some adults with disabilities may not need full legal oversight. They may simply need support in other areas. In those cases, less restrictive tools may be more appropriate, such as supported decision-making agreements, where your child retains decision-making authority but receives guidance from trusted individuals. You could also use powers of attorney, allowing someone to assist with healthcare or financial decisions when needed. HIPAA authorizations allow you to stay involved in medical conversations. These options allow your child to maintain more independence while still ensuring they have support in place. And for many families, that balance is incredibly important. Regardless of whether you choose a guardianship or an alternative, one tool that is often essential is a special needs trust. This type of trust allows you to set aside funds for your child's benefit without jeopardizing their eligibility for public benefits like SSI or Medicaid. Instead of giving assets directly to your child, which could disqualify them from these programs, the trust holds and manages those funds on their behalf. It can be used to enhance their quality of life by covering therapy, education, travel, personal needs, and all of this while providing access and preserving access to those critical benefits. There's also an important non-legal piece to this planning. Think about creating a letter of intent. This is not a formal legal document, but it can be incredibly valuable. It allows you to share your child's daily routines, their medical needs and preferences, their social connections, what brings them comfort, joy, and stability. In many ways, it's a roadmap for future caregivers, written by the person who knows your child best. Planning for a child with special needs is not one size fits all. It's layered, it's personal, and it evolves over time. Whether guardianship is the right path or whether a more flexible approach makes sense, the most important thing is having a plan in place. One that provides protection, preserves dignity, and gives you peace of mind about the future. If this video helped you think about your options, please like, subscribe, and share it with someone who may benefit from the information. And if you're ready to start building a plan tailored for your family, we're here to help guide you every step of the way. Thank you for joining me, and I'll see you next time.